Let's discuss immigration as a whole in the United States of America, from definitions and different ways of entering the country, quote unquote, legally, and ICE's various powers and your rights when encountering them. First, the definitions portion to better understand this conversation, starting with habeas corpus, not an immigration specific word, but a word we should all have a understanding of, defined as a right requiring a person under arrest to be brought before a judge or into court, especially to secure the person's release unless lawful grounds are shown for their detention. Other terms, such as immigrants and migrants, are not provided a universal definition under U.S. law. However, an immigrant is universally classified as an individual intending permanent settlement, while a migrant is a person seeking temporary residence. U.S. law, on the other hand, categorizes persons on their specific status, such as aliens, which refers to any person not a citizen, and the term foreign born being frequently employed in U.S. Census Bureau data research, which encompasses all persons without U.S. citizenship at birth, including naturalized citizens, lawful permanent residents, refugees, asylees, temporary visa holders, and unauthorized immigrants. Other common terms one should know the definition of include persecution, the hostility and ill treatment, especially on the basis of ethnicity, religion, sexual orientation, or political beliefs. Refugees, individuals who have been compelled to flee their home country due to war, violence, or persecution and are unable to return unless or until conditions in their native land are safe. This particular status is officially determined by the government or the United Nations Refugee Agency based on a well founded fear of persecution. Refugees apply for the status from outside of the United States and are admitted into the country if approved, subject to an annual cap set by the U.S. President at the start of each fiscal year. Then we have asylees, individuals seeking international protection from dangers in their home country, but their claim for refugee status has not yet been legally determined. A key distinction is that asylum seekers must apply for protection from within the country, meaning they must arrive at or cross the U.S. border to apply. Unlike refugees, there is no cap on the number of asylees who may be approved each year. Both refugees and asylees, once admitted, are eligible to apply for green cards or lawful permanent residence and eventually U.S. citizenship. Then we have the term forced migrants, a broader category that includes people who are compelled to migrate due to various factors, often beyond their control. And secondary migrants is a term that refers to individuals who have undertook another movement after the initial migration. It is important to know that the misuse of these terms in the media can be used to influence public opinion and policy decisions. The legal system relies on distinct categories such as these, while public perception is often shaped by a larger and more undefined terms. The legal pathway into the country is composed of two visa categories: immigrant visas, which confer permanent residence, and non immigrant visas, which permit temporary stays for specific purposes. Let's further break down the various types of visas and their uses, starting with the family based immigration, the most prevalent pathway. Within this category of immigration, we have immediate relatives, which includes spouses, minor children under the age of 21, and parents of U.S. citizens with no annual limit. Then you have the family preference visa, which is designed for other family members, including adult children and siblings of lawful permanent residents or U.S. citizens. This option is subject to strict annual limits and can have a long waiting time for approval. Now we have employment based visas, the second most common pathway for legal immigration, and usually requires an employer to petition on behalf of an immigrant to fill a specific job role, and is categorized into 5 preference levels that prioritizes the individual's set of skills and abilities. Then we have diversity visas, which is commonly referred to as the Green Card Lottery, and is a program that makes 55,000 diversity visas available annually and is designed for individuals from countries with historically low rates of immigration and serves to provide more diversity in the U.S. And finally, we have refugees and asylum seekers, as previously discussed. Next, we have non immigrant visas, which are designed for temporary stays in the U.S. with an intended purpose and a defined validity period. The type of visa needed depends on the applicant's intended travel purposes and other relevant factors, starting with business and tourism, which includes a B1 visa for business visitors and a B2 visa for tourists, vacationers, and pleasure visits and medical treatment. Next, we have work visas, which is a broad category that includes specialized visas such as E1 treaty traders, E2 treaty investors, E3 Australian professionals, H1B specifically occupants requiring highly specialized knowledge, H2A temporary agricultural workers, H2B temporary non-agricultural workers, L1 intra-company transferees, O individuals with extraordinary ability in sciences, arts, education, businesses, or athletics, P performing athletes, artists, or entertainers, R1 religious workers, and TNPB, which is NAFTA professional workers from Mexico and Canada. Next, we have student and exchange visitor visas. I hope y'all are sticking with me here. Next, we have student and exchange visitor visas, including the F1 visa for academic students and the M1 visa for vocational students, and the J1 visa designed for cultural exchange visitors, including professionals, scholars, and teachers. We are in the home run here. And finally, we have other specific categories, which encompasses a range of specialized visas, including A, diplomats or foreign government officials, C, transiting the United States, I, media or journalists, Q, international cultural exchange visitors, T, victims of human trafficking, U, victims of criminal activity, K1, fiance to marry a U.S. citizen, K3, spouse of a U.S. citizen awaiting I-130 petition approval, and B, spouse and children of a lawful permanent residence. All right, we're at the end of that. Aside from the traditional immigration and non-immigration visas, the U.S. also offers a vast array of humanitarian relief measures that allows for certain individuals to enter or remain in the country temporarily and does not typically offer a direct pathway to citizenship, starting with humanitarian parole, which is granted on a case-by-case basis to individuals for an urgent need to enter the country, such as for a medical emergency. Recent policy changes have introduced significant shifts in these programs, however. USCIS has ceased accepting applications that require Form I-134A, and certain specific parole programs, including the Ukrainian parole program and CBP-1 parole. However, processes for individuals from Cuba, Haiti, Nicaragua, and Venezuela have continued due to a court order. Next, we have temporary protected status, which is granted to individuals from designated countries that are confronting armed conflict, natural disasters, or other extraordinary and temporary conditions that make it unsafe for their nationals to return. Then we have T, non-immigration status, which is a visa specifically designed for victims of severe forms of human trafficking. It allows eligible victims to remain and work in the United States for an initial period of time for up to 4 years. Eligibility generally requires the victim to assist or cooperate with law enforcement in the detection, investigation, or prosecution of human trafficking acts. U, non-immigrant status, which is available to victims of certain qualifying criminal activities, including but not limited to domestic violence, sexual assault, hate crimes, involuntary servitude, and human trafficking. Those granted this status can remain and work in the U.S. for up to 4 years and may be eligible to apply for a green card if they meet specific requirements. Eligibility typically hinges on the victim's assistance or willingness to assist law enforcement in the investigation or prosecution of criminal activity. Finally, we have the Deferred Action for Childhood Arrivals, DACA. Although not a direct pathway to legal status or citizenship, DACA provides temporary protection from deportation and work authorization to eligible undocumented immigrants who arrived in the U.S. as children. The current administration has indicated plans to end DACA or cease renewals, introducing significant uncertainty to hundreds of thousands of recipients. Let's discuss the various legal protections for immigrants and migrants in the U.S. It is important to note that all individuals within the country, regardless of their immigration status, are afforded fundamental constitutional rights and specific protections under a variety of federal laws that aim to ensure fair treatment, prevent discrimination, and safeguard basic human dignity. First, those in the U.S. have the constitutional right of due process and equal protection, found under the 5th and 14th Amendments. The 5th Amendment applies to the federal government, and the 14th Amendment applies to states and states that no person shall be deprived of life, liberty, or property without due process of law, nor denied equal protection under the laws. The Supreme Court has consistently ruled that these clauses apply to all persons within the United States, including those who may be unlawfully present. This means that individuals cannot be deprived of their liberty or property without fair legal proceedings. Another constitutional right provided to all persons in the U.S. is protected against unreasonable searches and seizures, found under the 4th Amendment, and is crucial during encounters with law enforcement, including ICE. It is important to remember that ICE agents are generally required to obtain a judicial warrant signed by a judge specifying the address and areas searched. Lastly, you have freedom of speech, assembly, and religion, found under the First Amendment, which protects persons' rights to free speech, peaceful assembly, and free exercise of religion. This means ICE cannot target persons for participating in a peaceful protest, and a federal district judge has the power to determine if ICE has exceeded its authority by targeting persons for exercising their First Amendment right. Aside from your basic constitutional rights, there are many federal statutes that provide protections against discrimination and exploitation of immigrants and migrants, including the Immigration and Nationality Act, INA, anti-discrimination provisions which prohibit employers from discriminating against U.S. citizens, U.S. nationals, and authorized aliens based on their national origins. It also prohibits discrimination based on a citizenship status against U.S. citizens, U.S. nationals, and certain authorized aliens. This means an employer cannot have a policy of only hiring U.S. citizens unless a specific law, regulation, government contract, or executive order mandates it, which is a rare circumstance. Then we have Title VII of the Civil Rights Act of 1964, which prohibits discrimination in various aspects of employment, including hiring, promotion, discharge, pay, and training on the basis of race, color, or national origin. This protection extends to all workers, irregardless of their work authorization status. Enforcement of the Title VII is primarily carried out by the Equal Employment Opportunity Commission, EEOC. Next, we have the Violence Against Women Act of 1944, related to provisions that allows non-citizen survivors of domestic violence, child abuse, or elder abuse to self-petition for lawful permanent residence status independently of their abusive U.S. citizen or LPR spouse, parent, or adult child. This pathway is designed to provide victims with safety and independence from their abusers. Lastly, we have the Fair Labor Standards Act and other labor protections, which are federal and state labor laws that extend protections to all workers regardless of immigration status. Undocumented workers, for instance, are legally entitled to minimum wage and overtime pay under the FLSA. They also possess the rights to a safe work environment as per Occupational Safety and Health Administration standards, and can report safety violations without fear of retaliation. Speaking of your rights, let's talk about U.S. Immigration and Customs Enforcement, or ICE, which is an essential element of immigration control in the United States, and having an understanding of ICE's power and legal constraints is crucial in comprehending the broader conversation of immigration in the U.S. ICE is a federal law enforcement agency and is a component of the U.S. Department of Homeland Security, or DHS, and was established in 2003 in response of the September 11 attacks, and consolidated elements of former U.S. Customs Service and Immigration and Nationalization Service, or INS. ICE has stated its mission being to enforce federal laws pertaining to border control, customs, trade, and to engage in activities such as immigration enforcement operations to investigate human trafficking, financial crimes, and cybercrime. ICE has the following powers in regards to arrest, detention, and removal. ICE officers have a broad authority to arrest non citizens who are unlawfully present in the country. For arrests, ICE commonly employ administrative warrants, which are signed by an immigration enforcement supervisor, and ICE is responsible for detaining removable aliens. However, in many cases, ICE does not have the final say in regards to if an individual should be deported, with most cases being referred to the Executive Office of Immigration Review, or EOIR, also known as the Immigration Court System. And in this setting, the foreign national is afforded an opportunity to contest the alleged grounds for deportation and present any relevant defenses, such as those seeking asylum, claiming mistaken identity, or other forms of relief. If and when an immigration judge issues a final order of deportation and all appeals have been exhausted, ICE then assumes responsibility for the physical removal of the foreign national to their country of origin. It is important to note that ICE's broad sweeping powers to question, arrest, detain, and deport non citizens are often exercised through administrative warrants, which are signed by immigration enforcement supervisors, not a judge. This is a key difference between ICE's initial arrest authority and the typical criminal arrest. Now let's discuss your rights when interacting with ICE. While ICE may use administrative warrants signed by supervisors for arrests, entry into a home still requires a judicial warrant signed by a judge. Also, the ultimate decision regarding deportation rests in the hands of an immigration judge, not ICE. And individuals retain the right to challenge their removal in the previously discussed immigration court. Now, when interacting with ICE, officers, immigrants, and migrants are owed the following rights: the right to remain silent. You are not obligated to discuss your immigration or citizenship status, and anything that is stated to an official can later be used against you in immigration court. You are owed the right to counsel. If detained, the individuals have the right to consult with a lawyer. However, it is not required to be offered to you for free, but you can request a list of low cost or free alternatives. You are owed the right to refuse unwarranted searches, which requires a judicial warrant. And it is important to remember that those over the age of 18 are legally required to carry their immigration papers and must present them if requested by an immigration agent. Always remember to remain calm. Thoroughly document encounters if you feel that your rights are being stepped on, and keep the door closed. Speak to ICE agents through closed doors or windows. Opening the door slightly does not technically grant them permission inside, however, it is less secure. Always ask for identification and a warrant, and refuse entry if no valid judicial warrant signed by a judge is present. If stopped in your car, stop safely, provide minimal information, and refuse unwarranted searches. And if arrested, assert your rights immediately by clearly and loudly saying you wish to remain silent, and ask for a lawyer immediately. State your fear to return to your home country to every agent, and contact your embassy if applicable. This concludes my feature on immigration in the U.S. Come back next week for my shorter but just as important feature on the recent changes to immigration laws in the U.S. Thank you.